Let's bring in a legal expert. Ion Meyn, assistant professor of law at UW-Madison. Appreciate your time. Professor, your reaction to this verdict.
Yeah, Ben, I wasn't surprised. I am troubled by the verdict in the sense of what it means for self-defense. I think that the jury probably considered the fact that this is a 17-year-old boy who was engaged in this activity, and I think that probably impacted and rightfully so impacted the result. But in terms of what it means more broadly for self-defense in the United States, I find it troubling.
What do you mean by that?
Well, you know, the issue is how much discretion does someone have when they carry a firearm to use deadly force against someone who is unarmed? And we heard pre-trial when the prosecutor asked the expert, if Mr. Rittenhouse had not been armed and was aggressed upon in the same way by Mr. Rosenbaum, could he have used deadly force against Mr. Rosenbaum? And the answer was no, which raises the question. If you have a firearm, you have more discretion to use deadly force against others. And that was really an undercurrent in this trial, and then surfaces that issue for the nation to discuss, if that's the world we want to live in.
Well, the nation is certainly discussing this. I mean, we heard from former President Trump and President Joe Biden just days after all of this happened last summer. We obviously just heard from Joe Biden just a short time ago, basically saying that the jury has spoken at this point. What is your take on political figures, very big political figures, the biggest in the world, commenting on cases like this and potentially prematurely?
Right. I mean, it's good as to the last point. As to the first point, it just reflects that we watched this as a nation because there were TV cameras in the courtroom. I thought that was an extraordinary moment. We've had a couple of moments like that in our history. And it allows everyone in the nation to be watching on how the criminal justice system works to a certain degree, and to then make your own decision as to whether or not this is a fair process. And I think that's really important. And also important is the issue. We are determining in a sense on how we value life in the United States and what it means when we encounter each other. And this is really close to what our identity as people are. And so I understand leaders weighing in on this because it is a moment of cultural significance in the United States.
But do you feel that a lot of people didn't necessarily watch the entire case gavel to gavel? They just heard snippets on whatever news channel they favor, that maybe they weren't getting the entire picture here and then jumping to judgment, as many people do. I mean, we're all human. I think we all can admit at some point we've jumped to judgment prematurely. But in something like this that can have so many ramifications and can lead to potential violence and riots and all the things that many in the Kenosha community fear and still fear as of this evening, you know, where are we as a nation when it comes to that?
You know, it's a really great set of observations and questions. I don't know if I can answer any better than anyone else. I do think that as a lawyer, someone who has litigated really complex, high-stakes cases in the criminal system, there is a sense that one gets of alienation because no one really knows outside of the stakeholders in the actual trial what all the facts are. And as you say, people get snippets and things like that. But at the same time, the opportunity to watch this is there. But to your point, yeah, we only have limited time to absorb this, and we are going to bring our own, obviously, lived experience and ideology into this debate. But I still think that the transparency that was permitted here by the media being there and the discussions that have occurred, there is a healthy aspect to it. I understand, certainly from emails I've received, there can be some pretty mean and harsh and fairly not really dialogue interested kind of contributions to the debate. But there has been a lot of vigorous debate. I can see it in my classrooms about what's going on and what this means. And I think that's probably a good thing.
Taking a live picture on the left there, that's demonstrators on the steps. They've been there since this verdict was read. They're chanting, hanging out right now, and Ion Meyn continues to join us here. Let's talk about the decision. You say your students have debated this. The jury, 12 of them, all were able at the end of the day to see this the same way.
This is something that always surprises people because in my mind, it's unquestionable that there were divisions ideologically within the jury that reflects some of the divisions within the community. I mean, that's just what happens when you have a jury of your peers. It reflects generally the community's values, generally depending on the community reflected in the jury. But I imagine there was some division. And so the question is a great one. Why was this not just automatically a hung jury? But I actually think juries are really encouraged to find accountability or determine that the person in their mind their actions did not rise to a level of criminal liability. Again, there could be civil liability in this case, but as to criminal liability, there's a lot of pressure on the jury, and they've heard a lot of the facts, and they've felt the tension in the room. So I think the responsibility that they feel is much more acute than us watching from the outside. And the idea of coming together in consensus is a little more natural for a jury just because of the unnatural circumstances that they're under such intense pressure to come to some consensus.
You brought it up, so I'm going to ask the question. Do you think that we could see a civil trial involving Kyle Rittenhouse in the future?
Well, absolutely. It's a different standard of proof. It's a different set of dynamics that lead up to an outcome in a civil case. There's depositions. There's much more searching inquiries into the facts than you actually get on the criminal side. And so facts that you may not have discovered on the criminal side are often discovered in civil litigation. That may be good or bad for either party, but they change the dynamics of the litigation and the outcome. And in addition, there may be more because of the civil litigation is different and the repercussions are different in a civil trial, there may be a settlement that you don't get in a place where it's kind of an all or nothing situation on the criminal side.
I'm not an attorney and I'm not a professor of law. Can you talk about the standard of proof, how it might be different if this does go to a civil trial compared to what we just saw in this criminal case?
Yeah, and by the way, just to be really professorial about it, a lot of social scientists say that the standard of proof doesn't matter. It's just who has the most plausible story. But I would also think that anyone who's a criminal defendant would want the highest standard of proof, right? And so on the criminal side, the prosecution has a burden, which is beyond a reasonable doubt, which is supposedly the toughest. I don't think it is. There's one that's clear and convincing, which I think is a tougher standard. But we go with beyond a reasonable doubt. On the civil side, it's like a 51%. Which one's more likely? What's the more likely story? It's called preponderance of the evidence. And so it's a lower standard that a plaintiff, say if there's a wrongful death claim by the family of, say, Mr. Huber, Mr. Rosenbaum, the standard that they would have to show of wrongful death is a preponderance of evidence, not beyond a reasonable doubt like the prosecution.
You know, listening to you talk right now, it just is a nice reminder that all of us sitting here watching all of this from home, if maybe our viewers at home have been those who have just been glued to our YouTube channel watching this case day in and day out, we're not attorneys. We aren't in the weeds. We don't know all the language and the lingo and the statutes and all that sort of stuff. So when it comes to jumping to judgment, you know, we all have to be really careful when it comes, especially with a case like this where there is so much evidence and video evidence that is proof if you can see it clearly enough.
Exactly right. And when I talk to my law students, I am talking to them about the fact that they are learning a language, and that language tends to exclude others, right? And there's an aspect that it's important to have a certain discipline in language to ensure that there's shared understandings about what that language means. But at the same time, the risks are what we're seeing, and that creates misunderstanding between what the legal system is doing and for the people watching kind of outside the law, what's going on and trying to understand what the outcome is.
We're joined right now with Ion Meyn from UW Law School. Kyle Rittenhouse found not guilty on all 5 counts. Ion, I want to ask you, Mark Richards, we heard from him, that's Kyle Rittenhouse's defense attorney. He took a couple of shots at the prosecution. He says justice is done when the truth is revealed. And he said this case became about winning for the prosecution. Do you agree with that?
Well, once you're in litigation, that's kind of obvious. Both parties are heavily invested in the case. And it's true that the prosecution made early decisions in this case to prosecute Mr. Rittenhouse. But anyone looking at the film could come to reasonably two different conclusions. So I don't find it unreasonable for the prosecutor to have brought this case. Again, I've been pretty clear that I don't think they should have prosecuted Mr. Rittenhouse as an adult. He's a 17-year-old kid. I understand that's the law in Wisconsin, but I just don't agree with it. I think he was a juvenile and should have been processed in the juvenile system. But that's what it is, and that's what the law provides. And there was a basis, certainly, that this was a criminal act. And so I don't think that I think it's an unfair statement in this case, especially where you see a nation that's absolutely divided about it, that people on both sides have very, very different views, and one could argue they're both reasonable. And so I don't see what Mr. Richards is saying there. I don't really agree that the prosecution just brought this to win. I think they were invested in it because the video for many people was really shocking.
Do you believe the prosecution brought forth the correct charges in this case?
Yeah, that's a really good question. I mean, in certain respects, I understand that the first charge against Mr. Rosenbaum was reckless because in the end of the day, the video doesn't show a clear view of what happened. And then on the same token as to Mr. Huber, you could see the entire incident on video, and there you had an intentional homicide charge. And to me, that makes sense. Those kind of assessments by the prosecution, in both situations, someone died. But there was a different level of charging based on the evidence available to the prosecution. So I saw a basis for the charging in this case.
Ion Meyn from UW Law, we really appreciate your time getting that instant reaction to this verdict that just came in.